One unfortunate incident of a young judge where I think he had to commit suicide because of some issues.
She called me in the chambers and she said that, look, what do you think if we bring you on this side, on the bench? So I smiled. I said, my Lord, you may not be knowing, I'm only 38.
More important than have a goal, but more than working towards the goal, we should do what we can do currently the best.
I never went out of way or tried to do something to
That I wanna
gain entry to the
become
Supreme Court or to become. Client who was there, he didn't understand. So he said, ਬਾਊਜੀ ਕੀ ਹੋਇਆ ਜੱਜ ਸਾਹਿਬ ਕਹਿੰਦੇ ਨੇ ਮੈਨੂੰ ਸਮਝ ਨਹੀਂ ਆਇਆ ਇਹਨੂੰ ਸੁਪਰੀਮ ਕੋਰਟ ਲੈ ਜਾਓ
Did your family ever say ki, or dad or your wife, that you're not with us all the time, you're so busy in Supreme Court, and now you're even busier? So how did you manage your personal life?
That sacrifice had to be given. Of course, the family was understanding, they understood, but still, I feel sometimes that yes, no, I have not done justice to them.
So there has to be some, in my mind, some affinity towards being a judge. So what was that?
With power comes responsibility. You may have done wonderfully well as a law student. You may have topped. You may be a gold medalist. But if you can't work hard in this profession,
We have waited for more than a year for this episode to trace this person down to Beyond Billables. He's someone who's been a gold medalist and has won several academic accolades. He's someone who's worn all three hats of a senior advocate, of a judge, and now an arbitrator. His much enviable career is now getting decoded in this special episode of Beyond Billables. Who am I talking about? You guessed it right. Justice Sikri, former Supreme Court judge. And in this episode, we are going to cover not only his personal life, but also and ultimately what are the judicial gymnastics which go through the mind of a judge in deciding some of the most pivotal matters like transgender rights, death row convicts, and some of the landmark decisions like Aadhaar. In this episode, you will get the opportunity to step in the mind of a lawyer, a judge, and someone who's really passionate about work. I'm so excited. In fact, I'm super excited for you to watch this episode. As always, lots of love and keep watching us. Thank you from Beyond Billables. Welcome to Beyond Billables, sir. It is such a pleasure to have you.
it's my pleasure entirely. Thank you very much.
Sir, you've been a senior advocate. You've been a former justice of the Supreme Court. And I know for a fact you're an accomplished arbitrator. You've basically covered the three most important destinations in a lawyer's life. How did you plan this, sir? How did this happen?
You see, there was no planning as such to, say at the outset. One simple reason, as I compare when we were children or even in early youth with today's generation, I think there's remarkable difference. In our time, we would hardly think about future, at least future career, etc. Most of the time, what your parents would say, you are driven by that. But as in comparison, I see now even a child in 7th or 8th standard or even earlier would know what he or she has to become in life. So therefore, anyway, in our system, everybody has to go to school. So in school, there was no such thinking as far as I'm concerned. To tell you, my father was a senior advocate practicing in Supreme Court. So therefore, he had a desire that I become, being the eldest son, so I should become a lawyer. So therefore, maybe because of that reason, while in the high school and when I joined college, so I thought that, okay, I started looking forward to become a lawyer because he wanted it. To be very frank, those were the days now. The way things used to play in those days. At the same time, I also know the kind of hard work which he would do as a lawyer. And we would see many times our school will be early morning. So at 6:30, you wake up, you get ready for school, you go to school. You don't see your father's face at that time.
He was
And
working
no, it's early
early
morning.
morning.
So, but by the time you come back, I mean, he comes back, you are already asleep.
Asleep.
So many days in a week, it would be like that. So, and going by the kind of hard work which we would do or he was doing, so my mother would say many times, because naturally she was deprived of his company greatly, that I'm not going to allow him to become a lawyer. So that I still remember, those are also in mind. But yes, keeping this when it is the high school, okay, if I have to become lawyer, let me do my graduation in commerce. So I could get very good marks in my higher secondary. So therefore, I could easily get admission
Shriram.
in Shriram College, from where I did BCom honors. And then, of course, I joined law after my BCom honors. So by that time, when I was in the college, and even before that, as far as my father's desire was concerned, as I told you, but I had also accepted that I have to become a lawyer.
Wow. So at that point of time, did you ever resist being a lawyer? That there's too much of hard work and maybe too much time away from family.
Yeah, okay. As I told you, when I would see my father working so hard, uh, and my mother resisted in the beginning, or maybe it was not resistance, maybe out of anguish or anger. And certain occasions she would say like that, look, you don't give time to us, and therefore why should I
And you miss the person also.
yeah, you miss the person. So therefore she would say, no, he's not going to become a lawyer. But I think that didn't deter me, his hard work. To be very frank, as a student, I was studious. I used to read a lot, study a lot. So therefore, maybe maybe unwittingly, I never thought that, okay, so much hard work will be involved, and therefore I should not become. I don't think that was
It's
ever
naturally perhaps
deterrence.
ingrained in your
Possibly, maybe.
in your living style, in your DNA, that okay, I am already doing so much work, so this is nothing new.
Or maybe it didn't even occur to me that way.
Wow. And then, sir, what was the atmosphere like at home? Would you all discuss some cases that your father was doing at that point of time, or some interesting judgments coming about?
You see, when I joined law, of course, not before that, when I joined law and was doing law, sometimes if there is very interesting case, and at that my father would tell me, or particularly those occasions when he had argued the case and opponent was very strong person, Attorney General of India or somebody like that, or very senior advocate like in those days, Mr. Ashok Sen, Palkiwala and
Of
all that.
course.
So he had appeared against them also in few cases. So he would come and would be very happy that today I faced them, and I was able to convince the court. So, and those occasions, he will share those anecdotes and what were the nuances in that particular case which was involved and how it did. And I tell you, interesting, when you are asking me, I remember another instance.
Please, sir, please.
Yeah, what happened? It was sometimes I was in Delhi University Law Faculty, so we had this case law method. So of study where will be given the cases, reported cases, and which we have to study and we have to prepare on that basis. And class discussions were also like that. We call it case method study. So he was narrating one case. There was one issue of civil procedure code which was involved, and it was, I think, res judicata between co-defendants, something like that. I don't exactly remember. And so he was saying that this is one I am studying a lot on this, and tomorrow I have to argue. So I said, oh, there's a one judgment of 1895 of the Privy Council which was given and which we are studying, and you see this judgment. So he saw this judgment, he was very happy, and next day he came that I have won the case on the basis of that judgment. And the judges were admiring from where you located this such an old judgment. So I told them that this is the advantage and that my son gave me this judgment. So then one feel very elated, okay.
Yeah.
So in this way we used to discuss sometimes, but not very regularly, yeah.
And then, so when you stepped into law, did you have, again, a plan or a sort of a destination in mind? Now, I also want to go down the path of building my practice and then eventually, let's say, becoming a senior advocate. Or how did the practice actually start for you?
See, I told you, my father himself was
A senior
an
advocate.
He became senior little after my joining the law, or my joining the practice, not at that time. But then I tell you, frankly, many people don't know about it. In the beginning, I joined he was Mr. at that time, B.N. Kirpal, who became judge later.
Of course.
So he was practicing in the High Court. So I joined him because he was one of the most prominent advocates of the High Court at that time.
Truly.
So therefore, my father requested him, and he took me as his junior. So I worked with him for some time. But what happened, I was doing my LLM as well, along with my profession. I started, I joined LLM as well, and the LLM in the morning, which was 2 years course, you can do, or you cannot do part time, in the sense that along with that LLM, you cannot be, if you're doing LLM, you are not permitted to practice, etc. Since I wanted to be in profession as well, so I did 3 years course from Evening Law Center, Delhi University. So many times I had to attend classes in the evening. So I would sometimes leave early, but you have to sit in the office. Just
When
for
your
your
senior is
proper
there.
preparation, etc. So therefore, to be very frank, Justice Kripal or Mr. Kripal at that time never refused whenever I wanted to go. So he said, yes, please. You can leave and attend the class. But I myself thought that it is not very appropriate. So I said that, look, give me some break. I'll join you back. He said that also. He said willingly, yes, you can do that. But before I could join him back, he joined the bench.
Joined the
So
bench.
that occasion did not arise. And because of that, then I mostly worked with my father. But good thing was, my father had that kind of trust in me, if you say, or he thought that I have the capacity. From very beginning, he started giving me the cases. Okay, you go and appear in these cases yourself. Within 1 or 2 months of my joining the bar, I would go to the High Court and I started arguing the matters. So that kind of encouragement was given by him. That is the liberty he could take. But many times in our profession, people say that you should not join in your family anybody, because they may be your senior at that time, like in this case, my father would be lenient to you. He's my son, of course, and all that. And therefore, it is better to join somebody else. Maybe that was the reason that I joined Justice Kripal initially. But he was strict disciplinarian as my father is concerned. So, and he would take work as if I'm working as one of the juniors only with him, along with other juniors which he had. So, and of course, he gave me good chance, and I did well on those matters. So, with that, confidence grew from very beginning. And as far as becoming senior is concerned, yeah, when you joined in the very beginning, you can't think of becoming senior. You have to just, I always feel that things come at a legitimate time when they are due to you, and you have to earn for that. So it's not that for becoming senior, you have to have practice for 15, 20 years.
Right.
So minimum.
Right, minimum.
So therefore, let me concentrate on my work if I am doing at that time. Yes, when I was close to 40, then I naturally started thinking, yes, I should become senior. And fortunately, I think at the age of about 41, 42, I think I became senior.
And sir, during this fantastic journey, did it come a point where you said, the law is very overbearing? Maybe I should try something else. And I'm asking because I'm seeing a lot, and perhaps you're also witness to this kind of change, or churn in the market, what is happening with the current lawyers. So I just wanted to contrast between what was it like then versus now what's happening.
No, frankly speaking, after joining law, I never thought of any other profession or changing gears and giving up this practice and join something else. But to tell you two things. Number one, when I was studying law, at that time, you see, I saw many of my friends were appearing in UPSC exam for IAS exam. So I also got some interest. I said that let me also try appear and whether I'll be able to crack those examination or not.
Out of curiosity.
Out of curiosity. So I told my father that, look, I know you want me to become a lawyer. I promise you, I assure you that even if I am selected, I will not join. But let me make an attempt, whether
For the kick of it.
and whether I'm competent enough to qualify for that exam. But he did not allow me. Maybe he was a little worried that if I am selected, then at that time I may not.
It would be very difficult to refuse.
Difficult. And to tell you, there was another friend of ours. He was 1 year senior to me in law, and son of a businessman. Whose father. And so after finishing his law, immediately after finishing in law, there were exam, judicial service exam.
Yes,
so he told his father that, look, allow me to appear in this exam, and don't worry, even if I am selected, I will not join.
I'll come back to
I'll because you need me in your business, and therefore I'll join the business. But what happened? He did not. He
got through.
He joined judicial service. Ultimately became a High Court judge also. So therefore, maybe that my father had this kind of. Fear that if I am selected, I may not join. So he said, no. We concentrate that much in law. Law is one subject where you have to work hard, and you should build your foundation here itself while studying law. So therefore, I'll advise you to concentrate on law. So that is one thing which I thought of, yes. But after joining the practice, as I said to you earlier, I never thought of, because I was from day one, I tell you frankly, I was very contented with what I was doing as a lawyer. I felt that, yes, I am doing hard work. With hard work and commitment, if I am doing the cases, and these clients are coming to me, so it is better that I remain here because I am satisfied with what I am doing.
And you were perhaps also feeling the growth in yourself as a lawyer.
Yes, definitely. That I felt growth in me also as a lawyer.
So on your almost nearly 20 years of journey before you became a senior advocate, did you do anything different, let's say from your other colleagues, in terms of growing yourself as a lawyer, in terms of advocacy, or let's say cross-examination at that point of time, or improving your oral advocacy before court, or reading of files?
See, I think some of the tips which we were given are the tips which everybody is given, and therefore everybody knows. Like when it comes to advocacy or arguments in the courts, we are always told that, look, you should sit in the court even if you are not having any case, and see how senior advocates who are very accomplished advocates, how they argue. Just watch them, observe them, and you will learn a lot. And that is really correct. That many times, and that is why nowadays there's so much emphasis on clinical education, that students at that level only should visit courts. They should become interns with lawyers also, judges also,
and
so that they are able to see the profession even when they are studying law very closely from lawyer's point of view also, and from judge's point of view also. And that is one very, very good opportunity, I would say, for students, because you are able to sit in the chambers of the judges. You are able to find out how they work, what goes on in their mind when they discuss with you the cases, etc. Okay, this is a case listed tomorrow. Do research on this, or maybe at the time of judgment, what is the thought process and how they are deciding the cases. That helps you when you are arguing the case. You don't become judge immediately. When you are arguing the case, what is the psyche of the judges and what they and that make you good advocate. So therefore, I mean, those things I would do, yes. And when it comes to cross examination, again, there were, I know, in the Delhi High Court on original side, there were 3-4 very, very good and sharp advocates, and the art of cross examination was unparalleled. So I had observed them. In my free time, I would go to and sit in the court if they were cross examining any witness, etc. I would observe how they are doing that, and what are the do's and don'ts, and even the books on art of cross examination. So even theoretical knowledge. So I was that way always. Inquisitive about these things. So I think some you see studies on these subjects, some observing others, and then the way you act, and over a period of time you improve yourself,
improve your craft.
Exactly. So this is what I would say, and that is what I will tell the junior lawyers also, to pick up these habits.
Sir, you make it sound so easy.
No, it's not easy. You are right. It's not very easy at all. But it is not insurmountable.
Yes,
People,
yes.
And we have seen the, lawyers who are so good in
Absolutely,
their oratory
sir.
skills, and so good in advocacy, and the way one should. It's also like battle-like situation, and how you, in the sense, organize yourself, how you plan the things yourself, how the case should move, how it should go on. So those are the tricks to be learned. And which one may observe, one may himself or herself. Learn about those
while practice and trial and error.
And best thing is practice. Yeah.
Practice. So when you became a senior advocate, and the point after that, just before you were asked to be elevated to the bench as well, to Delhi High Court, what happened there at that point of time? Did you decide to go on this journey, and this opportunity came by, and or was it like, okay, this looks good, maybe I should also become a judge and see that side of the profession?
It's a good question. Going by what was happening in my family at that time, I tell you first, this, even before I became senior, I was only 38 years of age at that time. Justice Sunanda Bhandare, she was very senior judge. She was at number 3, I think. I used to appear a lot before her. She called me in the chambers, and she said that, look, what do you think if we bring you on this side, on the bench? So I smiled. I said, my Lord, you may not be knowing, I am only 38. She said, oh, you're only 38 because you have matured so fast. I thought that you must be at least 40. So in those days, one should be minimum 40 to become a judge. So that, okay, wait for 2 years, but then we'll bring you on this side as soon as possible, as soon as you turn 40. As it happens, when I turned 40, at that time, feeling in the judiciary was that one should be minimum 42 before he becomes judge. When I became 42, at that time, it was, of course, it had not happened at that time, but normally thereafter, it was that one should be 45. But to tell you, as far as I'm concerned, I was, as I said, around 42 and a half when I became senior.
Yes.
But I still remember, within 2 days of my becoming senior, the Chief Justice at that time invited me, and he said that we want to send your name. So at that time there was no hard and fast rule that one has to be 45. So anyway, he sent my name, but of course other names also went, and 45 at that time President of India. Also, there was some unwritten rule, or I would say practice or convention, that one should be 45. So President of India at that time was very strict about it. No, you should not send the names. So many of these names kept pending for quite some time. So I'm not going into that history. But ultimately, when I turned 45, although my name was sent before I turned 45, but it was processed after I turned 45. But I was 45 plus 1 or 2 months when I became judge. And so that is how. But yes, to answer your question, when this Chief Justice called me and wanted to send my name, I had developed this, to be very frankly,
the affinity
to switch over and become judge. But my wife was resisting it a lot, and she's also a lawyer, by the way. So she said, "No, don't become. The kind of money which you are earning, etc."
I was about to ask you that. the so pros and cons.
Yeah, pros and cons. You should not. And very frankly, when I gave my consent, I did not tell her. I knew that she would not tolerate it. She came to know only after 10 or 15 days after that, and she was furious. Of course, we had a debate, but then I convinced that, look, money is not everything. I have never felt like that. I'm telling you, that way I'm a very contented person. If I'm earning, I was earning well, I was happy. But if I have money, I may indulge into luxuries also. But if I don't have,
you're okay.
And I'm okay. I'm equally satisfied. Which happened, in fact, after becoming judge, naturally your earnings come down very sharply. And what I was earning a day became my monthly salary. So therefore, that happens. But then I never repented. I was very happy. So I told her also when we were that, look, this is the money which we have saved is in our bank account. In those days, the bank interest rates used to be very high. I said that, look, X would be your income, interest income. Then we have a house. We will be given accommodation. So we'll rent out our house. We'll have rental income. Rental income was also very high in those days. And you will also earn something, I told her. And I'll also have salary. And we have only one child. There's no future
nothing to
liabilities
worry about,
and all. It's only his education, who had just entered law college. So only his education, and then maybe on his marriage. So how it matters. Ultimately, she was happy. And good thing is that after she accepted, she was also contented, and
that was the right decision, sir. I think in hindsight also, we can all say that.
Yeah. So this is how my transition from lawyer's days to my,
becoming a judge, crossing over.
Yeah.
So if you don't mind me asking, what was that point of time that captivated you to become a judge? Because as you said, the life of a senior advocate, even now considered by all of us lawyers, is considered to be of a high emblem, of a high prestige. And of course, earning well, you're doing a lot of good matters. And that's the point when you will end up doing even better matters because you've become a senior advocate. All those questions are there. So there has to be in my mind, some affinity towards being a judge. So what was that?
You see, tell you two things. Number one, I have been a sincere and serious student throughout my life. And thereafter, and because of that reason, I've been topper as well. I don't know.
You've been given scholarships as well.
Yeah. In law, in LLB, it's in Delhi University, 3 years course at that time, 6 terms. So I can say with pride, I topped all 6 terms
And you were gold medalist there.
and gold medalist. So therefore, I had that kind of inclination. Our constitutionalism, rule of law. I tell you, there's one prize in Delhi University law faculty that if you get maximum marks in the constitution, so there's a separate prize for that, which also I got. So therefore, I studied this constitution a lot. I really became very fascinated about it, and our constitutional value, constitutional ethos, what were in the minds of constitution framers when this constitution was enacted and all that. So therefore, it was some kind of social service, you may say, in the mind, or some kind of giving back to the society. That was always in mind, and justice to the poor. Of course, both, I would say, when it comes to giving justice to the marginalized section, doing social justice, and justice in any other matter as well, whether even a commercial matter. So it's always, I would say, it's a joint venture where lawyers also help a lot. Without the help of lawyers,
It's not possible.
judges would not be able to do anything. But even having said that, I think as a judge, your role is really profound role, a different kind of role altogether, which I always thought it's a service to the nation. It's not that, yes, you get much powers, no doubt, and Indian judiciary is treated as the most powerful judiciary in the world
In the
even
world,
today.
absolutely.
So you get much powers, but I have always felt with power comes responsibility. So I would look at responsibility first. Even when I thought that I should become a judge, it was that, yeah, I have to be service oriented. I have to serve people. That was always in mind. And I thought that as judge, I will be able to do better than as a lawyer. So, and I
Create more
feel
impact
that
on the society.
and I feel that I think I have been able to do a bit in this direction. Therefore, I've been very contented when it comes to, accepting judgeship and doing, contributing my bit for
To
this
the society
welfare
and
of
to the
society.
nation.
Yeah.
So you were on both sides, being a judge, being a lawyer. How do the two view the same matter differently?
You see, it's very easy. As a lawyer, one side is coming to you, correct? And your role is, and that is your duty also, to plead the case of your client who has approached you. Sometimes, and you are also a lawyer, I have also been a lawyer, sometimes you know even that the case is not strong or the cause is not very justified. Still, we do that is our duty. We do that and we leave it to the judge or to the court to decide. But yeah, as a lawyer, my function is to do. So, as a lawyer, your function is to defend or to plead the case for your
Advocate the case of the client.
advocate the case of your client. But as a judge, you are now seeing both sides and who is right, who is wrong, where justice lies. So this is a primary difference between the roles on two sides. So therefore, at the back of your mind is that you have to do justice, and justice lies in giving relief to X or in giving or deciding the case in favor of Y. And so therefore, judge role is in that sense different. Yes, when we say that lawyers have to help the judges in arriving at justice,
Yes.
but there the lawyers are on both sides. So both are helping. So therefore, you pick up one or you are convinced with one thing, whether it is, plaintiff who is right, defendant who is right, or it is petitioner or the respondent who is right and wrong, and you decide accordingly.
So therefore, you have to have a holistic view of the full matter.
Correct.
So as a judge, did it ever happen to you that you would get a sense before even the arguments really go into detail that this seems like a losing case, let's say for the plaintiff or for the appellant for that matter, and or here is a lawyer who's, for lack of a better word, is trying to be cute in court. Do you get that sense right when you're at the beginning of the matter itself, sometimes?
In 90% of cases.
Oh,
You see,
wow.
it depends on.
So we have no scope to outsmart the judge.
And that applies to all judges are able to. I tell you, I'm telling the reason. It all depends also on which jurisdiction you are sitting. Correct. When I say 90%, it applies to Supreme Court judges clearly, because by that time, High Court judgment is there. It may be at two levels before it comes to. So it may be, after two innings or maybe three, the matter is coming to. So the Supreme Court has the, in Supreme Court, when the matter SLP comes, we have already read. So we know, whether there's even an iota of chance in this matter or not. But even in the High Court, again, it would depend upon what kind of jurisdiction you are sitting. When it comes to writ petitions or when it comes to appeals, you are in a position to discern, even after reading the case, how much worth or how much merit a particular case has. And on original side, or when it is the first time case, a plaint comes, you are not able to, because there it depends upon what is going to be the defense of the other side. Much will depend upon that, and more than that, what is the evidence which is going to be led. But yes, after evidence, etc., and then when the case is ripe for hearing and the argument starts, you are able to find out which side is right, which side is wrong, and where you should go. And so therefore the degrees may vary accordingly, depending upon the nature of the case and the
what level
it is. But generally, talking about the cases, I always say there are hard cases and there are very simple or easy cases, we call. So again, I would say 90 to 92-3% cases are easy cases. Easy cases in the sense, after hearing the matter, you are, or even when the matter is being argued, and it would apply whichever level, whichever level you are sitting.
Level of the forum you are
sitting, it will apply, and you are able to decide those easy cases, because they have only one way or to go about it, and you know what is going to be the outcome. 6-7% or 8% cases come in that category of hard cases, where, because of several reasons, it is not easy to decide. It may be because of the facts of that particular case, which say either both the sides are almost equally to be blamed, or they are equally, in the sense, wronged. Equally wronged or equally justifiable.
Yes.
It becomes difficult to decide who is right, who is wrong. Second category would be the types of issues which are involved, particularly in a country like India, where there are so many social issues still we are grappling with. And there are issues which are directly connected with the society. I'll give you examples also, where, because we have to keep in mind, law and society have very deep connect, particularly when it comes to such social issues.
The intersection between the two.
Take a case of, I'm giving you a live example, Sabarimala is being argued.
Yes.
Now, society would be equally divided in a case like this, because of their personal views, convictions about such kind of issue. Take the case of LGBT. Again, you will have equally divided society. Take the case of this, whether there should be, marital rape. I'm giving you, these are those
tough ones, really hard ones, the 7-8% ones.
Exactly. So therefore, in such issues, when it and their society is directly concerned. It's not one person who is concerned. It's not a case where A versus B, their commercial dispute or their tenancy dispute or their partnership dispute.
Two major fractions of the society.
Yeah, here you are deciding about the how the society has to behave. right? Your extramarital relationship, whether it should be offense or it should not be an offense, whether it should, I mean, criminal offense,
Criminal
or it should
offense.
be only a civil wrong. And there are lots of debates about it, and all these cases are decided. So therefore, and there are umpteen number of such issues. So there, the first problem is whichever way you decide, a section of the society is not going to be happy. So, but as a judge, then your duty is to decide. These are, most of these have constitution flavor. So so therefore you have to decide in terms of what the law says or what our constitution says. Because
values in the
constitution is
Constitution.
supreme. So therefore, judges attempt to decide in that manner, but then interpretation of the provision in the context of that particular case, even constitutionally, would be debatable. Again, taking Sabarimala judgment. Now, if you see, there are rights, I mean, of the religious rights which are given to these denominations and religions, etc. So the basic what we say ethos or the principles of or any practices of a particular religion, they are not subject to, that is what is being argued, subject to judicial scrutiny at all. And fundamental right, it is made a fundamental right. So it is already a fundamental right for
Absolutely.
those religious
Yes.
communities. Now, vis-a-vis that, you have on the other side again a fundamental right of an individual, whether as a female, even if she is
So
during that period, whether she
practice
should
and
be
profess-
allowed to
yes.
enter. Why a person who is from the age of 10 to 50 and when she, from puberty to her menopause, why she should
Menopause.
not be allowed? Why this should be a reason? And the principle of equality, etc., come, women's right come. So they are both, on both sides, there are fundamental rights
And
involved.
very, very
And
compelling
you have to
arguments.
balance the two. And therefore, interpretation is possible even in applying the constitutional provisions to go in favor of either views. So these become hard cases for that purpose. I mean, in that sense. And as I said, whichever way you decide, yes, at the end of the day, it's the conscience of the judge, how he or she feels are the constitutional norms or constitutional principles which are to be applied, and decide that case and leave at that.
Leave at that.
But yes, this is one type of hard cases where we are talking about the legal principles, etc., and social issues. But as I said, first type of case also where you feel that maybe an individual case that both sides seem to be equally right. Number one. Number two, it is you decide in favor of X. Say one party is a petitioner. Then what is the decision which I am going to give? What is the impact of that on the respondent? Maybe because of that, the respondent is again going to suffer, whether that suffering would be undesirable, unreasonable,
Whether it's
and
fair.
fair. And likewise, if I decide in favor of the respondent in given situation
deny the relief.
and deny the relief, what is the harm which is going to be caused to the petitioner? So weighing that becomes really, really difficult. And therefore, they come in, as I said, in those hard cases where you have to think a lot. You have to think a lot. Many times we are able to, I'm saying from my personal experience, we are able to find out some balance where you are able to to justify your decision. And maybe, as I said, difficult case, but while, say, giving relief to the petitioner, you are able to take to some extent the interest of the respondent also, but not always possible.
Not always possible.
But then you have to do your best even in these circumstances. And ultimately, in such cases, you have to apply law. And so therefore, in deciding those cases, you have to really meditate in the sense, I'm saying meditate in the sense that, yes,
Of
you
deliberate-
keep
deliberate thinking,
deliberate
thinking.
thinking and all. And I've seen from my experience, many times you are thinking which way to decide, and you're not able to. That has I have always done like that. Still, you are not able to decide. Okay, start writing. the judgment.
The answer will come to you.
Answer while dictating the answer
come,
comes,
yes.
and sometimes wonderful answer comes
Much better than we were thinking.
We were thinking.
Happens in writing the opinion also. When we are also doing it, this is what happens.
So you can understand that.
Yes, a bit, but not at your level, sir. So, sir, this is amazing what you've actually shared, because when it comes to an advocate presenting their case, and now you've sort of given me a flavor of how a judge in the right mind would be deciding the matter. How should they best assist a judge? What are the things that they should be doing and not doing from your perspective, or maybe some incident that comes to mind, a fond memory of how somebody really assisted you, so that we can understand that.
So I tell you, generally, my advice would be, yes, when you are preparing the case, as I said, that duty of a lawyer to argue the case for his client, you will do that. In the process, whatever is the factual narrative, one should not try to mislead. Suppose there are some facts which are not favorable. One is, a very idealistic advocate will even frankly state those facts also, but then try to cover that these facts should not affect the final outcome of my case. That is the advocacy. Other way is, okay, let it be told by the other side. Why should I tell
And
the
then I will
weakness?
deal with it.
Weakness, and I'll deal with. That is also fair enough. But don't mislead. Don't, try to, while even if the, say, fact has come to the notice of the judge, then try to say that, no, it is wrong, even when it is come to the, or, try to brush it aside by,
Or diminish the importance of it in any way.
you, as I said, one can say, argue that, look, notwithstanding this fact, I have still a strong case. That's a matter of argument. But misleading should not happen in the process. You see what happens. You may try to mislead. One may be successful.
Yes.
But not always. Number one. And so the judges ultimately come to know. Here are I'm telling you frankly.
Where is the secret pipeline?
You see, I say in a lighter vein, once I said to the advocates when I was in the court, look, when you go out, you talk about us. But don't think that we don't talk about you. When we go to chambers or we are sitting in the lounge having lunch together, we also talk sometime about the advocates, or such advocate is very clever. He tries to mislead, or opposite. This advocate is very fair in his approach. He will always be forthright, but yes, argue the case effectively notwithstanding, but will never try to mislead. So that is the reputation, or bad or good reputation, when the judge, and it's not that it has happened in one court, so that it's only that court. Other judges also would come to know of this. So that plays a very, vital.
Because we are ultimately human beings, sir, and if that's the impression or impact we are casting on another fellow human being who may be a judge, then person is bound to rather talk about it or even think about it.
Yeah, correct. So very correct. So therefore, that is one thing. As far as factual narrative is
golden rule:
concerned,
never mislead.
don't mislead. Then try to do your best. And when it comes to, because it's not that you are appearing for a client, you have to win every time. If your client, and many times we know, as lawyers, we know that our client has no case. So we try to do. So we even tell them. I many times to senior lawyers in the Supreme Court, I would say, when SLP comes after 1, 2, 3 minutes, when I'm saying there's nothing in that, and he's insisting. So I'll say jokingly, Mr. So-and-so, yesterday when you had a conference with your advocate on record, along with the client, you must have told them there's nothing in the case. You are still trying, I can understand and appreciate, but you know there's nothing in this case, and you must have told them yesterday. Did you tell them? And then he will laugh and he'll smile and he'll stop. So therefore, not that lawyers don't come to know. Yes, try to do your best, but ultimately you also know what what is his strength, what are the weaknesses. Not that lawyers don't know. And it should not be pushed beyond limits. There are some lawyers, even when they know, but they will still try unnecessarily. But then I would also say that even if there's not much in the case, but a lawyer who is arguing the case thinks he has the impression that he has a very strong case. This happens many times. If the judge has not decided in your favor, you come out and you are not satisfied. No, I had a very strong case, but the judge has not understood, and it's injustice which has done to my client. It happens. I'm not saying that, but yes, ultimately it is a judge. You have to leave it to him. And yeah, there are further opportunities open if it is not the
convince
Supreme
your
Court
case.
that you have still go in appeal. I again remember of one anecdote, very interesting anecdote. I was sitting in the court at that time in the High Court. So there was one judge who came, one advocate who had come from district court, and a Punjabi fellow. His client was also one Punjabi and a rustic man, and so it was civil revision, section 115 CPC against interim order. And the scope also is very, very
revision
limited.
is very limited.
So the judge in the High Court was not listening. I mean, not listening means not convinced. And when he was arguing, the judge said, no, there's nothing in this case. There's nothing in this. Sorry, I'm not going to interfere. Order is perfect. He tried to convince him 2 times, 3 times. He didn't agree. And he said, dismissed. And what happens now? The client who was there, he didn't understand. So he said, Bauji ki hoya? and it is happening in the
Delhi High Court.
In the Delhi High Court and within the hearing of the judge. Of course, I know judge was a non-Punjabi, so whether he understood much or not, I don't know.
This is pre-virtual times. So
much pre-virtual. I'm talking of this must be early 81, 82. So, Bauji ki hoya? And the lawyer also says within the hearing of the judge साहब कहते ने मैनू समझ नहीं आया एनू सुप्रीम कोर्ट ले जाओ. So what he meant was that okay, we'll go to Supreme Court if he's not.
But that's a very clever way of putting it.
Way of putting it and telling the judge also that look, we are not happy. But anyway, these things do happen. But you do your best, and you should not, an advocate should not, have that kind of emotional attachment with the brief. That if, the result is not favorable to his client or what he desired, that yes, it should be like, it has still not come. Maybe advocate is right. And it is unfortunate, but that doesn't mean that, now you were so emotionally attached that you keep then thinking about it and, saying, and it has spoiled your mood or everything.
And most important, spoils your objectivity of the case and the next steps.
Yeah, next step. So many times you see you have more than 1 cases, 4 cases, 5 cases. The moment you come out from that court and now you're going to another court, so just forget about that, at least for timing. In the evening, you can again discuss with your client and now you concentrate on the other. But what I'm trying to say is that no emotional attachment should be there. Yes, commitment has to be there. You have to do your best. You have to try to do your best, but then leave at that.
Wow. Oh, that's very helpful, sir. And sir, in your journey when you were sitting as a Delhi High Court judge, and let's say you were new in the role, did you feel that you also needed guidance on, how to go about deciding? Was there some mentorship also accessible to you at that point of time on how to do the role of a judge in the right earnest, in the right sincere way?
I tell you, it's again very good question. Normally, whenever a person is appointed as a judge, he is made to sit with a senior judge, always in division bench.
Yes.
The purpose is this. And if the senior is good, he will keep on giving you tips also. You are sitting on the bench, matter is being argued, he'll keep telling you this is happening and all that. So that way, he's guiding you as well.
Learning on the job also.
Learning on the job in the court, and then you are observing him also. You are watching him, how he's dealing when a difficult situation comes in the court. A lawyer is behaving in an improper way, how he tackles that. Sometimes all kinds of
Yes,
lawyers are
yes,
there,
yes.
all kinds of litigants are there
Yes.
who sometimes keep shouting in the court. So how he is dealing with those situations. So you learn from that. Then after the matter is heard and the judgment and the two judges are discussing, then your senior tells you that look, this is what was argued, this is what was argued, and it should be dealt in according to him. So suppose case is to be decided, appeal is to be allowed, then what are the reasons, what was why he find, not that you are not able to, but then he would tell you, give you his own assessment about the case and analytical assessment, if I may say so. So you learn from those. So you have to observe a lot. You have to take those as the tips given by. Sometimes tips are given specifically by senior judges, which is really good. And so therefore, all these things one learns by discussing with the senior. You are sitting with one senior, then you are sitting with another senior. Then when you sit singly, you are able to now
Apply all of that
apply all
also.
those, and whether you are successful in that or not. So these are some of the things. And many times I've seen many junior judges, even if he's sitting single and he has some problem, we reach out to their seniors and ask them how to deal. Even the court behavior also, if somebody has behaved like this, will go reach out and says, sir, guide me, or there's some problem, legal issue, etc., which has a reason. And so there are always good seniors who always try to help their young colleagues.
So that mentorship access, in a sense, is available,
Yeah,
and
yeah.
guidance is available, because
Yes.
it's also important to learn how to do it. Ultimately, it's also a task and a responsibility, as you said.
Yes.
So let's fast forward to your Supreme Court journey. After spending a lot of time in Delhi High Court, just like when you were thinking at the age of 40, I should be looking at maybe getting a seniorship. Was Supreme Court something in your mind, or it was like maybe after Delhi High Court, I'll just start practicing in other courts and be in
No,
Supreme
to
Court?
be very frank and truthful, when I become High Court judge, I had in mind I should go to Supreme Court also.
Good. Thank you for being honest.
Yeah, always, because that is always a desire. Once I have now come on this side, I should try to go to the
Yes.
highest position.
Yes.
That would be the I would say legitimate expectation and desire of any person.
And so, how did that transition happen? Was it because of late there are always some discussions by Supreme Court judges on who all need to be elevated from different high courts? You, of course, first went and became Chief Justice of Punjab and Haryana High Court as well. So, from there, was it a natural progression?
Tell you very frankly, as I've told you, desire was always there, but I never thought that. And yeah, okay, I have to now work towards this. There may be some persons who have in this mind that okay, now I have to become Supreme Court judge. Now, how should I become? What?
Yes,
I
yes.
mean, what I should do and all.
Absolutely.
But to be again very truthful, I am saying that when I was in the High Court, I always thought I have to give my best
To the job at hand.
to the job at hand, and it would be seen by the judges in the Supreme Court. And if I am doing my job rightly, and because of that I deserve to be in the Supreme Court, I will be called. So that was always in my mind, that today I'm a judge of the High Court, I am a Chief Justice of the High Court, I have to give my best performance.
No, you're right, sir, because I'm just going back, rewinding on the journey so far. When you joined law, you were practicing with your father, the same mindset that you just mentioned. Do the job well, do the job well. When you switched over and became a Delhi High Court judge, same mindset. And again, coming to Supreme Court, perhaps the same mindset which is happening even today. So my big learning here is, and maybe whoever's listening, that it's more important than have a goal. Maybe for people who are listening to us, have a goal, but more than working towards the goal, we should do what we can do currently the best.
Correct.
And then leave it to fate, destiny,
Yes.
whichever way.
I never went out of way or tried to do something to
That I wanna
gain entry to the
become a-
Supreme Court or to become. That let me, yes, do my work and earn that.
Earn that.
Yeah.
So, where did you get this philosophy from? Was it there since the beginning, or maybe seeing your
You see,
father?
I tell you, yeah, as well. Let me tell you another anecdote here of my father. As I told you, I topped in law. When the day I remember, first day when I was enrolled and was to go to court. So my father handed over me the book. It's a autobiography of Mr. Setalwad, was the first Attorney General of India. And he said, read it, it's very inspiring. And it was, no doubt. But before giving it, you read it, but he showed me one page and one passage from that, which I still remember and recollect, where he had written that, look, you may have done wonderfully well as a law student. You may have topped. You may be a gold medalist. But if you can't work hard in this profession, don't join the profession. So he also wanted to tell me, maybe you have also topped, but now you're coming to profession, forget about what you
That's a
achieved as a student.
past accolade.
Yeah, forget about that. As a lawyer, in order to be a successful lawyer, you have to work hard and you have to start from scratch again, because it's a different terrain now. It's a different ball game now. I mean, practicing as
You're
a-
right, sir.
So that is what his message was, which I took it. So, good thing is, I would say good thing, or he had faith in me. He had trust in me that, yeah, I can do well. He had, even when I was a student, he had expectations from me. And I knew that, and he would say also that, no, he will perform. He had all that kind. But then as an advocate also this, but he still wanted me that, yes, there are no, free lunches. You have to work hard to get your legitimate due, or if you want to really be a good lawyer at that time. So you have to work hard. So that is one, I would say his not only inspiration, but yeah, this is a lesson which I learned from him. And at the same time, would say my mother, her name was Shanti, and she was really, true to her name. She was very, peaceful in
Calm,
mind, that lady,
serene.
very calm, contented in the, so, and with lot of humility. I would say that this kind of habit I have tried to learn from her. So it may be that in the different ways, both my parents have inspired me.
Wow. And sometimes a very small thing like this, some lesson, can really help you achieve very, very good things in life. The same mindset that you spoke about. How was it different from being a Delhi High Court judge? How was Supreme Court different?
You see,
Other than the appellate jurisdiction, the
that I'm in another way I'm saying, there are two things, if I may say. First thing, whether you are a High Court judge, whether you have been a civil judge at the lowest rank, or you are a Supreme Court judge, your first job is to do justice, not only decide cases. Well, decide cases is job of everyone at all these ladders, and while deciding the cases, you have to do justice. So that is the same obligation or duty cast on every judge at any level. Difference is in the sense, again, number one, in the High Court, when you are sitting, and if you are deciding something, of course, you will decide after any conscientious judge will say, yeah, I should decide in a right way. But still, you have one feeling, even if I have committed some wrong, if I am wrong, it will be corrected by the appellate court. If I am sitting as a single judge, by the division bench, and then Supreme Court, if I am sitting as even division bench, by the Supreme Court. So there is one more level where even if my
correct it.
wrong, but when you are in the Supreme Court, you know now it is the last court. So responsibility is much more, although work is same. deciding the cases and doing justice, but the responsibility is much more. Because if I err, of course, not that in the Supreme Court also, if that is done, I can be by larger bench overruled, etc. But that may take time. So in the
And it's
meantime, if
much
a
more
wrong
cumbersome.
decision may have become, will do harm. So therefore, the responsibility is much more onerous. So before deciding, we have to think a lot that look, what we are doing is not wrong. And because now there's nothing to correct, there's no appellate court now in that sense. Review is different thing, and so that is one, which makes you more conscious about the case which you are dealing, and much more responsible. Another thing I would say in a different and in a lighter vein, the difference is there's so much of work in the Supreme Court, so much of work. Although it's a special petition,
You're saying much more than High Court.
much more than High Court in the sense that with the SLPs, etc., which are listed on Mondays and Fridays. And now I tell you, for these SLPs for Mondays and Fridays, you are almost reading entire week. For your Mondays files, you Friday evening, when you have done your Friday evening work, you start you getting files, you read some files on Friday evening itself. Then you are reading on Saturday also, Sunday also for Monday's files. You have to be totally ready because it's in 2 minutes, 3 minutes you have to decide. There were 60 cases, 65 cases. So you can't have this, that, okay, I'll listen only in the court and then I'll take a decision.
Which is perhaps the most unique feature of Supreme Court in India, which is not there anywhere in the world.
Anywhere in the world, you are right. In Supreme Court, United States Supreme Court, these are taken up in the chambers only. SLPs are not taken up in the open court. And so that is one. So you are reading on Friday, Saturday, Sunday. Monday you do it. Maybe Monday evening you are little free. Not free in that sense, I'll come to that, for Friday cases. But from Tuesday, files will start coming. So Tuesday, Wednesday, Thursday, you are reading for Friday. Now, Tuesday, you have some nowadays miscellaneous cases are SLPs are also listed. But then there are after notice miscellaneous matter for final hearing. So Monday evening, you read that. So all 7 days, you have to read so much. And in this, I have not factored the orders which you have to pass, the judgment which you have to write, the cases which you have heard.
And the research,
and you have to the research, taking of, and apart from that, nowadays, so many seminars, so many conferences.
The extracurriculars in that sense.
Extracurricular in that sense. And so you have to, do those. So there's so much of work. So that's the second aspect in Supreme Court vis-a-vis High Court judges. Not that in High Court they don't read or High Court they don't work. Yeah, I'm not saying that. They also are burdened with work, but in comparison, maybe I'm saying.
And the level of reading which is required on a continuous basis.
That is much more in the Supreme Court, yeah.
And sir, do you also feel, purely from a skill set perspective, does a Supreme Court judge, to handle the kind of workload, to be that decisive, to be able to take quick decisions, does it require a different skill set as well, which one has to develop?
Sure. It has, because I have seen, of course, since I was in Delhi, as advocate, I practiced in Delhi High Court, also Supreme Court also. So I was acquainted with, and I was familiar with the way Supreme Court works, not judges, but at least the functioning of the Supreme Court, etc., when I came to Supreme Court. But many judges who come to Supreme Court from various high courts, they tell us that for few months, they're totally, they feel that the working of Supreme Court is totally different from the way they used to work. And they get time to familiarize themselves with the functioning of the Supreme Court. And of course, but good thing is that a judge who is coming to Supreme Court has already spent 12, 13 to sometime 15, 16 years. So it's not that, so she knows the art and craft of judging, which is the fundamental function. And therefore, adapting to the kind of practice or in the Supreme Court and the way judges have to decide in the Supreme Court, it doesn't take much time.
And so, since you've been on the bench in that sense in Supreme Court, before getting a High Court judge elevated to a Supreme Court, what would one look at in terms of qualities and some technical skills that you already said how to judge? But what else would be required to come to Supreme Court?
You see, number one is the most important thing is as you have yourself mentioned, and while sitting in the Supreme Court, and because this is the function of the collegium, correct?
Yes.
A judge who by the time he or she reaches the collegium, they have already spent 5 years, 6 years, or about that much time as Supreme Court judges, and then they have come to this collegium. So, two things which happen. One thing is that yes, in the when they have been deciding for 5, 6 years the cases, the appeals from the judgments of all these judges are coming. So we are able to find from those judgments, reading those judgments, yeah, he writes so well, or his judgments,
thinking.
clear thinking and all. So when many times we admire, but two judges sitting and they go, "Wow, how beautifully well this judgment is written by such and such judge." So therefore, the name of that judge coming again and again strikes, yeah, he's a good judge and he should be picked up. Sometimes we think like that. But then apart from that, even if the judgments are not coming or so frequently not coming, but one comes to know from how it is happening from the various methods of knowing that. So therefore, we would say that yes, for the main thing is a person who has become a judge has been judged for 13, 14 years. So by that time, her skills as a judge are known. The way the cases should be decided, etc., are known. So one has the general assessment by the time you reach collegium about these judges on the basis of which the decision is taken. And I'm very frank in saying that, yeah, if the decision is taken objectively.
Objectively, yes. So that's very, very important. So let me also talk about your decision on the transgender matter. And I see that perhaps as a person or maybe as values that you've taken from family, you are always trying to balance. How was it like when you were on the bench deciding that matter and also authoring the judgment?
I tell you, there's something.
And so at that point of time, that was hugely covered. It was a very important issue for the society as well.
Yeah, let me tell you, because I think I have told earlier also, so therefore there's nothing in hiding that particular fact, although it relates to how we judges have decided that issue. When me and Justice Radhakrishnan, who were on the bench, so we both, after hearing the arguments, etc., and going to, they were passionate about this. Yeah, here is a community which really needs justice. They have been deprived of so many things, and rather, we would say that they have been excluded from the society. They have not been become a part of the society, and the way society has treated them in an uncharitable way for hundreds of years. So they need to be given their legitimate due, and inclusivity is very, very important factor. And even today, when we talk of only gender, we say he and she everywhere in all forms, etc. They are not even recognized in that sense. So both of us had become very passionate about it. Yes, some justice in some form or the other is legitimately due to them, and it is to be given. After the judgment was reserved, I told Justice Radhakrishnan, I want to write this. He was senior.
Yes.
He said, no, I want to write the judgment. I will write. The senior has the say. There's no doubt about it. So he wrote the judgment, draft judgment, he sent to me. And I don't know, I was busy in writing some other judgments or so. This kept pending with me for almost about 2 weeks. And one day when we were sitting, I told him that because I was feeling little, it's not just on my part, that I'm
because of the other workload and your
holding on to this. So I should have given. I said that, and after he had written, because I had a desire to write, I also wanted to write. So then after 2 weeks, or maybe little over 2 weeks, I told him one day that, look, I know I have to give that judgment. I have seen that. And that is perfect and all, but I want to add something and write my opinion also. So if you don't mind, if you give me 1 week time, I would like to write that. He encouraged. He said, no, brother, by no means. I mean, no question about that. If you want to write, please do write. We can pronounce after 1 week also. And I am also trying to fine tune it little further. And you see, at that time, I was thinking the judgment which was written by him took care of, it's a beautifully written judgment by him.
All the legal issues
which
they covered.
took all legal issue,
Yes.
constitutional provision, etc.
The rights, everything.
But I thought one thing which is not in that, on which I wanted to write, was that the entire issue should be looked into from the dignity point of view. That dignity as an individual, dignity as a human being.
That's a fundamental right.
This dignity, is their right also, that they have to be treated with dignity. So I then added only that, maybe 20, 30 pages,
Yes.
entire thing on dignity. And I feel that, this is the best contribution which I could give to that judgment. And thereafter, in so many cases, I have written from that angle. Like when it came to rights of disabled persons, there's a judgment of Jija Ghosh with that name, authored by me, and where one she was a disabled person on wheelchair, but an activist. For the fighting for the rights of disabled persons.
People.
And she was going to, I don't know from where, Hyderabad or somewhere, to Goa somewhere, and it was more than 2 hours flight, and she was not allowed to be boarded and deboarded on the ground, that we don't know what happens to you on the way, long flight and all.
And we don't take responsibility for that.
Exactly. So therefore, in that case also, I thought that, look, the way she is treated, and it is totally, devoid of dignity, that even if a person is disabled, not that it's only that, no, something may not happen. That's not a reason that you deprive these persons of their rights. So therefore, in that also, I developed the concept of dignity of human beings.
Right to life with dignity under Article 21.
And which I then was able to develop it in so many ways, in so many judgments. So that is what I feel, that yes, my contribution, and I
even
feel
in the
happy
death row,
about
sir,
that.
Even in the death row case that you take, some inmates were
correct.
6 of them, I think 4 or 6 of them were acquitted at the Supreme Court level as well.
That's another case which shocked our conscience. This was one case where 5 or 6 persons who were accused, all tribals. It happened, it was from Maharashtra. And the charge against them was that they killed 4 or 5 persons who had gone there and all that. No eyewitness. And only from this circumstance, that they were, there, because they were tribals, they were residing in jungle. And since they were there, so they could have done this, which was, had hardly any,
evidence.
Remote connection with that or evidence with that. So the, I won't say interesting, but paradoxically, or
there's something disturbing in the case.
What I'm saying, the way treated and disturbing. Trial court convicted them, gave them death sentence. High Court upheld the conviction, confirmed the death sentence. Supreme Court specially petition dismissed. In the first instance, specially petition was dismissed. Supreme Court specially petition dismissed. By that time, what happened when it had was done, within few months, a judgment came. And again, I was a party a member of that constitution bench. We gave that in any case where if death sentence is involved, it should be minimum 3 judges, not 2 judges. And the cases which were decided in last years, 1 year or so, and where 2 judges can be reopened. So this case got reopened. And it is how it came before us, 3 judges. Now, even SLP was dismissed in limine without notice.
Without reasons.
And we find ultimately it's not that we have interfered with the punishment, that conviction upheld and we have commuted sentence from death to life. No. We found that there was no credible evidence even to convict them, and they were acquitted. So this is, from that sense, I find not only that how tribals were given that shabby treatment by judicial system, and that's why in that case under 142 we even awarded compensation to them. But more importantly, it is a very good example insofar as when the debate on whether death penalty should remain or should not remain, that comes. Here was a case, if SLP, and had that not happened, that 3 judges and all.
I'm also thinking, had that not happened,
those persons would have been hanged. Those, according to us, were not even convicted properly. So when we discuss about the whether death penalty should be abolished or not abolished, this becomes a classical case. So I see it more dignity, one thing, and
from the way whether the system has treated those individuals properly, and whether they got fair trial.
So that was shocking, and really, and all three of us, 3 judges, me, myself, Justice A.K, and Justice Nazir, I remember. So we really, at the end of the day, and after giving this, we felt so light. At least we have been able to undo the injustice which was done to them. Maybe, they have spent so many years in the prison, we can't help it, that can't be given back. But those tribals will have at least some solace and it was, they even did not know much about it, because at legal aid, counsel had appeared and who was arguing on their behalf.
So they didn't even have proper representation in a sense. Wow. So after Supreme Court comes your third innings. I see you more active than before. And I guess it's the number for you is you're 72 years young now.
No. Okay. I'm happy you are calling me young.
I know you're doing a lot of work in arbitration. One question I will ask you on arbitration as well, but more for me, as when I see you working this hard, what is inspiring you to still go on?
You see, passion for work, if I may say so. Yes, icing on the cake is that now I'm earning also substantially for 20 years, which I gave to the society, to the nation. And as I told you, I was very happy, even with the meager salary I was getting. I never had any cribbing about that. Very contented. But yes, I would say that God has been kind. People have been good to me. Maybe what I did or gave, the way I performed my task as a judge for those 20 years, that goodwill, because of that,
carrying forward, and you're reaping the benefits.
I've been able to get so much of work that I'm happy.
Touch wood, sir.
Touch wood. I only say, when people say that, no, you are even more busy than you were as Supreme Court judge. So my reply always is no. It cannot be, because, as I told you, the workload of the Supreme Court judges. So I always said that, look, there can't be anybody busier than the Supreme Court judge.
That workload is very different.
Yeah, workload is so much. So it's not that. Now I've been able to maintain some balance. I won't say entirely, but some balance between the work and my family life, etc., where family life was totally given a go-by as a judge. So, but then, and in that maintaining that while balance also, I've been able to recover all that which I deprived myself as a judge for 20 years. And God is kind, I would say.
Wow. So as a professional now who's doing a lot of arbitration work, this is more for the people who are practicing arbitration as well. What's the outside in perspective about India? When I say outside in, how is India being perceived globally as an arbitration market? The good, the bad, the ugly.
You see, I tell you, first thing, India, after it has ushered into globalization and liberalization from 1991
91
onward,
onwards.
is a different country. Correct. Maybe 91, and immediately, naturally, it took some time to change the
Certainly
ecosystem.
2000 onwards to has changed.
2000 onward, exactly. That is what I wanted to say. So, till 19, I became judge in 99. So, I had a lot of practice in arbitration. But the cases of arbitration, and mostly the domestic arbitration, which we used to do at that time, today the complexity of the cases, the nature of the cases is totally different, and the way arbitration world is now going ahead is totally different. Total, ecosystem has changed. In our time, I still remember most of the advocates, including me, we will do the arbitration cases, but like part time. We are doing our court cases first and then doing it in the evening or sometime in the afternoon, etc. And likewise, arbitrators were doing like that. There would be very, very few, there were very few who were totally devoted to arbitration. But today, arbitration bar has been developed. There are many advocates who are exclusively practicing on arbitration only. So they are available whole day. And so therefore, the talent has grown in the process. And that is one thing. Secondly, because of this globalization, the nature of, as I told you, arbitration disputes have changed. It is now more international arbitrations also there, which are there.
It's internationalized, as they say.
Internationalized, yeah. And so we are been able to imbibe the principles of international arbitration in international good practices, etc. as well. Complexity of the cases have changed totally. They have changed. The way they used to be conducted in those times and the way they are conducted now has totally changed, which I saw after coming on this side after retirement. And due to this good thing which has happened is that we have now breed of very, very good lawyers. There's no doubt about it. Many of our lawyers are as good as international lawyers.
As good as the English barristers or the American lawyers.
Yeah, exactly. Lawyers in other countries are good lawyers, and many of us would be even better than most of them. I can say that because I've done so many international arbitrations also and domestic arbitration also. So therefore, we have that pool of talent as well as advocates are concerned. Likewise, we have many arbitrators because there are many senior advocates, etc., who have developed as good advocates, are working as good arbitrators also. And some of them are really very good arbitrators as well. Many retired judges who are arbitrators, many of them are again very good arbitrators at international level. So they compete with anybody. So therefore, when it comes to lawyers, when it comes to arbitrators, we have a pool of talent and who can compete with anybody. At the same and third thing, because of globalization which has happened is, and as India has naturally advancement which is made in economic field.
We've adapted well also to it.
Yeah,
The digitization.
and not only that, what I'm trying to say is that in the process, many corporations, international of multinational companies in India which have developed. So there's so much of litigation or arbitration work which is generated from India. Correct. So that also is there now. And to be frank, many of the institutions of other countries have so much work from India. They are thriving and surviving on Indian work. But in spite of all this, why India has not been able to become a hub for international arbitration. In domestic arbitrations, we are doing well. And there's no doubt about it. There are some shortcomings of arbitrations on domestic level. I'm
Yes,
not
yes.
saying that it is totally without any blemish, but then that is everywhere. Some of these issues are in other countries as well. So it's not that only India is suffering from that. So therefore, arbitration has become a necessity. Yes, we have to take care of those issues to make it more viable. That's a different thing. But it's not that, arbitration has to be given go by.
Yeah,
And
yeah.
but then how to make India as hub for international arbitration? That's a challenge
And
which
what's
we
the
are facing.
number one bottleneck there, sir?
Yeah, what so I see two things primarily, and there may be other also, but primarily if I highlight or mention the two things are, number one is the enforcement of the awards. You see, what happens many times. Again, let me take a step back and say this thing first. After the Arbitration and Conciliation Act was enacted in 96, and if you see for 5, 7 years, it did really well. Then there were 2 or 3 judgments which came.
Yes, we all know, sir.
We all know, I
Bhatia
don't have to,
Act.
exactly,
Yes.
Bhatia International and ONGC saw pipes. So, because of that, there was.
We were set back for a few years easily.
So, therefore, yeah, anyway, they are also taken care of. But then it was whether India here. I'm talking of judiciary, because we are discussing about the enforcement. Is arbitration friendly or not? There also, if you see in last 10, 12 years, remarkable judgments have come by the Supreme Court and even by the High Courts. Delhi High Court has given, Bombay High Court has given. Some of these judgments are really remarkable. I would rather admire many of my judges in the Delhi High Court who have given wonderful judgments in this and very progressive judgments. So therefore, one cannot say that we are not today arbitration friendly. But in spite of that, now and then some judgment comes by the Supreme Court because of which international community has this kind of feeling, you see, we lack certainty
And
in
consistency
our
and
approach
certainty.
and consistency. So therefore, whether in which way the court would go is not easy to depict. Anything can happen. And this kind of uncertain environment, international community won't want. That is one thing. Second is, even in enforcement, the time which is
Time.
taken. I don't blame the judiciary because of the reason that Indian judiciary is so much heavily
Inundated with
burdened
work.
and inundated with all kinds of work. Not that you can give primacy only to arbitration. Then, if you give to these commercial cases, what about those? We have criminal cases where people are languishing in courts and the trials have to take place. We have social causes, social issues, etc. We have cases for workmen. If they are not given their legitimate dues, or those who are marginalized section,
Service matters
those
are there.
service matters, those who are terminated and waiting for their judgment, so they are equal. So people say that they are equally important. Why we should look into this only? So these are some of the challenges because of which maybe we have not been able to decide that quickly, which happens in other jurisdictions. So because, and it is primarily, I'll highlight these two, because of which people, international community thinks that if India is seat and the award is subject to challenge under the Indian courts, then we don't know what is going to happen.
And sir, maybe a third factor which came to my mind is also the award is at the enforcement stage. Is asset recovery happening faster?
Yeah, that is
Also maybe another
I said about the timing,
connected
etc.
dimension to it.
So therefore, I generally said about the timings, but you are right in giving this stating this nuance also.
And you are sitting as a judge in the Singapore International Commercial Court. Is that also the feedback you hear and observe from other fellow judges from
No,
different countries?
they don't say much about this, particularly in the judges sitting there. They won't say much. But from my experience, actually, it was really sitting in SICC is a really, very good experience which I have got there. That is the kind of professionalism which is there, the kind of case management and court management which we are not able to do the way they give. Look, like if a particular case is to be heard and dates are to be settled, and I'm talking of court, not in arbitration,
Yes,
it
yes,
happens
yes.
in international
Yeah,
arbitration, but even in court, say SICC, I'm telling, they will, the registry will ask us our availability. They will give 3-4 sets of dates. So first, okay, let me tell you, they will first ask it's CMC, which takes place by the registry. Registry is very competent. By the registry
yeah,
with
their registry is another level of
another
professionalism.
level professional. They know much of the judicial work also. It's really interesting. And so they will talk with they know which way, the manner in which the pleadings are to be completed and the case is to be come up for final arguments. From time to time, they will keep seeking our, directions. That's a different thing. But all that is done. Not unlike in Indian courts, every case comes here out of 80 cases, in 60 cases,
All
the
the
court is
admin,
saying, do
diary
this, do that.
management,
All that is, the case comes to the court when it is for arguments,
for
either
pure
entire.
judicial thinking and decision making.
Yeah, exactly. Whether it is interim orders or final orders, but for arguments. But there, all that exercise is done by the registry. So they have just before the dates, they will ask number one, how much time you are likely to both the parties. And whatever time they give, and I'll tell you, the parties also give realistic time. Not that if the case required 2 hours, they will say 5 hours or 6 hours, or they will continue for days together, because uh, the losing side has to pay heavy cost. They know because of that cost, we may be burdened with such a heavy cost, which is real cost. So therefore, let us take that much time, which is necessary. So they will realistic time. They will say it. Sometime it is only 1 hour each. Sometime it is maybe say one day each.
And when they say 4 hours, it's actually 4
Actually,
hours
they are
worth.
given 4 hours only at the time of arguments. That's why I wanted to say that. But what I was saying that in CMC, so they say the time. Normally, parties are given equal time, and on that basis, they will ask 3 or 4 tranches of dates, depending on how much time they want. And then they will ask the judges, us also. So they will give those dates which are convenient to all parties, also judges also, because we are judges from outside. So it's not that we are sitting in their court, they are doing all. And now the case is listed, it will be done on that day. Precisely that much time which is given. And so this kind of case management and court management, which is really to be imbibed by us.
So why can't we do it?
No, actually, maybe one reason is that we are, so much of work here. But you are right, at the same time, it can still be achieved. Not that it becomes a challenge, but it can still be achieved.
And so, of course, as a judge, you would have seen this way more than I have in my career. But I see this also as a tactic sometimes. And we're all guilty of it. We'll say that we'll take 5 hours just so that the matter gets spilled over.
Yeah, it happens. We know it.
So I think one of the 2 or 3 things I've understood, having certainty in the kind of judgments we do, consistency, third, in shorter timelines, if you're able to do it, then we truly arrive
If
at the
we
level.
start imposing real cost here also, okay, I can understand. A worker is coming, he loses his case. We should not impose cost. But why we do not do it in commercial matters?
But there are 2 equally well-equipped parties.
Why we should do. The moment we start imposing realistic cost, all this will be automatically taken care.
I agree, sir. Even I think that's also going to raise the quality of advocacy as well.
Yeah.
So just last 2, 3 questions. We began our discussion by saying that you used to see your father not being visible for weeks. You also went through that journey. Did your family ever say, ki, or dad or your wife, that you're not with us all the time. You're so busy in Supreme Court, and now you're even busier. So how did you manage your
No, you are
personal
right.
life?
That personal, I mean, as a judge, that sacrifice had to be given. Of course, the family was understanding; they understood. But still, I feel sometimes that yes, no, I have not done justice to them. I may have done
Justice to them.
justice to others, but not to my family members. Particularly, I remember now when I wanted at least to be more with my grandchildren.
I met your lovely grandchildren. He's holding a box for you, which I'll give at the end. And he said, "Who's this for?" I said, "Your Datu."
So therefore, that always repentance will always remain.
So, to someone who's, let me maybe pose the question differently. If you're sitting across a 25-year-old young Mr. Sikri, how would you advise him to start his legal career?
No, legal career. Many things I have said.
Yes.
So what my dad told me, etc., I'll tell him that you start like this. At the same time, yeah, the mistakes which I committed by not being able to maintain that balance, I'll tell him that don't fall into that error. So try to maintain balance with your family and your work. And of course, work is worship, but work is not everything. We have to, do justice to the family and family members also. That balance is very, very necessary, which I could not.
And I also, so it's also unfortunate that a lot of people also say the life of a judge is quite lonely. Is that?
Not necessarily.
necessarily.
Again, it depends. Many have felt it is lonely, but again, it depends on your temperament, on what kind of person you are. I'm very happy in my social life with my friends, etc.
And also being with yourself.
I'm very happy being myself also. I'll keep reading, I'll listening to music, may watch movies, etc.
You don't get bored with yourself.
Yeah.
I understand. So there was this unfortunate news about this young judge.
Finish it.
Yes. Just one last question, sir. One unfortunate incident of a young judge where I think he had to commit suicide because of some issues. I just want to get maybe one sense for people. What is the pressure that a judge faces and how best they should handle it?
You see, I tell you, it has always been a discussion talk, particularly in lower judiciary, that we should look after when High Court is the guardian and they are in a way the our children, and at that time we have to take care of their health, which includes mental health also. And many times because they are very young, when a high court judge a person becomes high court judge, he's 44, 45, even 44, 5 plus.
Very strong temperament is there, maturity is there.
Although not that at that age also many face those problems. But at young age, because at the age of 27, 28, you become judge and you all of a sudden get so much of pressure of what I said, that challenges in deciding the cases also, which I said particularly about the hard cases, etc. as well. And I said that the judges, the essential function of all judges, whether it's a trial court level or Supreme Court level, remains the same. So therefore, whether they are able to mentally cope with this pressure or not, what is the mechanism in these? I think there should be some kind of counselors there, some kind of psychiatry, some initiative should be taken by chief justices, because this happened with that one Mr. Sharma, I think.
Yes.
But then there have been such instances otherwise earlier in other courts also. So therefore, it becomes a really, really alarming thing. And whether it was a person was undergoing some suffering because of family circumstances, because of work pressures, because of peer pressures. So sometimes some people go into depression that, look, my colleague is able to do so much, I have not been able to do.
Wow.
I have not been able to perform. That also happens. So there may be so many reasons. And at least the judges of the High Court, Supreme Court should take, we have judicial academies lecture now telling them, look, whenever you have a problem, there are always inspecting judges. Hey, reach out to us. Tell us. Don't hide it. So we are here to solve. And then whatever, if medical advice is needed or other kind of advice is needed, that should be given to them.
Wow, I think that's also a need of the hour. So very quickly, we have a rapid fire round. In a minute, I'll ask you questions. And the trick is you don't have to think, whatever comes first thing on your mind. The judgment that you're most proud of.
It may not be one, more than one, but transgender, which you said. Transgender, Jijabai Ghosh on disability, these two on social justice, Aadhaar in other sense that comes. There was one judgment in NEET case where, and even in Aadhaar, which I expanded, I feel happy that propounded that principle of proportionality in judging the constitutionality.
Yes.
So those kind of judgment, and the first two cases said where dignity I evolved on that. So I feel.
So there's a lot more. So second, one tip that your father gave you that you're still following today.
That is my father gave hard work, which I said. But apart from hard work, I tell you, he was a person of very, very high integrity, let me tell you. Not that he was my father, I'm saying. Yeah, I saw in so many circumstances when I used to and see him. But that is what I learned, that yes, to be in peace with yourself, you should be, you should imbibe this quality that at no cost integrity would be compromised.
If you had not gone into law, what would be your alternate profession?
Could be, because I was in Shriram College, might have become chartered accountant, or in law, as I said, UPSC, may have become IAS or IFS officer.
Sir, a book that changed you?
I've read a lot, but one novel which I really admire and even comes to my mind even today also, that The Alchemist.
The Alchemist, Paulo Coelho.
Paulo Coelho.
Even I love it.
It is really remarkable book.
So extremely imaginative.
Correct.
Wow. So we share a common favorite book. And this is personally selfish question. What does it take to become the top 1% lawyer of the country?
I would say here again, number one, hard work. There's no substitute for hard work. No shortcut, you can earn good money, but you can't become a good lawyer without working hard. You see the lives of all those who have attained great heights had worked really, really hard in their days. As it is always said that there are three phases. Our teacher in law, I remember she used to tell us the three phases in the life of a lawyer. First phase, work and no money. Second phase, work and money. You do work, you are compensated equally. Third phase, no work and money. Although it's not that no work, what it means was that relative to that you get much more than what you put in. So today a lawyer who is for 2 minutes appearance is charging 10 lakhs or 20 lakhs. That doesn't mean he has started charging now. It's a
it's a building process.
For 20 years, 25 years, 30 years, 40 years, when he has toiled and has reached that stage.
Toil is required. And lastly, sir, for the judges, please finish this sentence. The best judge is someone who?
I think function of the judge is to do justice. The judge who does justice without any fear or favor.
Wow. Thank you, sir. It was such a pleasure talking to you and learning a lot. So many pearls of wisdom. Thank you for coming to Beyond Billables.
Thank you very much.